Welcome to a very special episode of The Short Circuit. Today we are talking to two amazing civil rights lawyers about two recent cases, each litigated. Sam Weiss is the founder and executive director of Rights Behind Bars, where he litigates prison conditions cases, as well as other civil rights cases across the country. He is also a lecturer on prison law at Harvard Law School. Sam will discuss his recent victory in the Third Circuit, Montana's versus Price, a prison conditions case. Welcome, Sam. Elizabeth Cruikshank is senior counsel at Georgetown Law Center's Institute for Constitutional Advocacy and Protection. Like Sam, she litigates high-stakes civil rights cases against government of all levels, from your local municipality to a federal bureau of prisons. Elizabeth will talk about her case out of the Fourth Circuit, Frazier versus Prince George's County, involving rights of pretrial detainees. Elizabeth is also on the board of Rights Behind Bars. Is that right, Elizabeth?
That's right. A founding board member and very proud of that.
Very cool. So actually, you two know each other quite well. How about you tell our listeners about your history?
Sure. So we... Unfortunately, this is like sort of a small bougie world story, but we were both clerking on the Ninth Circuit at the same time, became friends then, and then both ended up back in D.C. I was working for a large civil rights organization. Elizabeth was working at a firm specializing in appellate practice. And when I first had the thought of starting Rights Behind Bars, which was the idea of tracking pro se conditions of confinement claims, which are almost all conditions of confinement claims, and trying to take some of those cases up on appeal, I asked some people who are much smarter than me whether that was a good idea or not. And Elizabeth is one of those people, and I was able to get her to be one of our founding board members, of which there were 3, and I was one of them. So it's not like this was a long list.
Who was your third board member?
It's actually too embarrassing for me to say. I have to keep that confidential.
A respected professor of business management.
Yes.
I love it.
Nonprofits.
Who maybe was my mom also. A smaller network I had back then. And in those early days, that first year, including the year that we litigated Taylor versus Riojas, which we might talk about, I was the only staff member. And so one thing I learned about myself is that if you put executive director in your email signature, you can just start emailing people and they will email you back. You don't have to direct anybody.
You heard it
actually.
First, people. Just put executive director in your signature.
That's right. And so it was a really exciting time. It was also really scary. And so Elizabeth, in addition to her many other obligations in her life, kind of took on a de facto sort of deputy director of the organization, and, supervising interns, editing briefs, all this on top of a very demanding law firm job. So I will... she's done us great service since then too, but I'll always be super grateful for those early days when she helped support what we were doing.
It was a lot, but it was also like really fun. It was like small, scrappy, like, interviewing fellows and stuff like that, like not sort of traditional board member activities, I guess, but like it was the work that needed to get done. And it was cool to be in the trenches, I think, setting up the organization. So as the organization became more sort of self-sustaining and I was not required, I was like, oh, I guess you don't actually need me to interview your summer intern crop anymore, which is a good thing for the organization. But, I experienced it as like, oh, okay, I guess I can take a back seat from some of this stuff.
Yeah. We hit a point as an organization where Elizabeth did not have to be on every email, which is, given that it was not her job, came due eventually. But we still plug her in.
No, it's always those kind of stories and memories are the best. That's how I think back to the project on immunity and accountability that Patrick and I started. At first it was just two of us and it was like drinking from a fire hose, but it was really cool. Like, yes, we were busy. Yes, we were tired, but we were like comrades in the trenches. And we had to economize and we had to come up with certain shortcuts and do things a certain way. But that was really cool. Looking back at it, it's like, yes, those are good times, but it's unsustainable to always do it at that same level. So I'm glad that you guys were able to transition out of that, as we did as well.
Indeed.
So you guys litigated Taylor versus Riojas together, and Taylor, our listeners will know, is essentially the biggest Supreme Court victory in the qualified immunity space since Hope versus Peltzer. Back in 2002. So could you two talk a little bit about Taylor and kind of like the behind the scenes stuff that our listeners would really appreciate?
Yeah, absolutely. So Trent Taylor was treated absolutely horrifically after the Texas Department of Corrections said that he had committed suicide, or pardon me, attempted suicide. He disputes this and put him in what was a suicide prevention cell, essentially, but was covered in raw sewage, he was left there naked, it was freezing cold. He moved between two of these different cells over 6 days that were sort of unspeakably awful, with staff making fun of him. We see this a lot with sort of self-injurious behavior by people who are incarcerated, that the staff are purportedly taking suicide prevention measures, but actually are just punishing them for making their life harder.
Yeah.
And so Trent, who's a very effective pro se litigator, despite not having much formal education whatsoever, he had actually litigated an excessive force case to trial, to verdict, and won, and was awarded $0 in damages in federal court, which is, juries are mysterious creatures. And so he got the case through summary judgment, or I should say he got the case to summary judgment and then lost on qualified immunity under the grounds that the district court and then eventually the Fifth Circuit, in affirming that decision, was doing what the Supreme Court had been telling it to do on qualified immunity, which was don't look at the fact that did these men have noticed that what they were doing was sort of unconscionable, because they unquestionably did. What the Fifth Circuit did was it looked at other cases and it said, well, we have a case that says unspeakably dirty conditions for a couple of years violates the Constitution, and we have a case for 3 days of really dirty conditions, and that doesn't, and 6 days is in between 6, and so it's like some kind of logic puzzle, as opposed to the purposes that qualified immunity is purported to serve, which is notice on defendants. And so actually what happened is that opinion came out on December 20th, 2019. So it was just a few months into RBB, and it really made the rounds because the defendants didn't actually contest, even on summary judgment, that they had done to Trent what Trent said that they had done. And so the opinion takes it as says this actually happened to Trent, as opposed to contesting the factual narrative, which is normally what happens in these prison cases, and nonetheless found qualified immunity anyway. And people were pretty horrified. And so this was December 20th. So it's the week before Christmas and everything starts to shut down. And as you know, Anya, you have 14 days to file a petition for rehearing en banc. Right. And the Fifth Circuit had been fighting a lot about qualified immunity. And I thought to myself, and I asked some people who were smarter than me, like Elizabeth, like, hey, could they actually go on? Could they actually take this en banc? And people said, yes, but you need to retain it. It's one thing to write the petition, but you need to retain him in the next 14 days. And so I sort of frantically tried to get in touch with him. It didn't work. The form from the Texas Department of Corrections, I think it's called the Texas Department of Criminal Justice, for attorney-client phone calls, you can only set it up if you have a pre-existing attorney-client relationship. So anyway, I'm calling these lines. Nobody's picking up because they're so understaffed, because people are calling out sick for the holidays. I just can't get anybody on the phone, and it's been a week. And I only have another week, and that's, sort of the 2 weeks of the holidays. And so, so I flew to Houston. I rented a car. I drove down there. I didn't know if he was going to be willing to speak with me. I didn't know if he would have already signed up somebody, with somebody else, or if he wanted to do it pro se. And I was finally able to talk to him, and I learned that he had gotten my letters, but of course he wasn't able to get letters back to me in time. And he actually hadn't been given the opinion. So he had no idea that he lost. He didn't know why. So, the first thing he said to me was, hey man, I really, you're the guy who's been sending me letters. I really lost the case. Why, how? And so, I think he was a little suspicious. I think a lot of people like Trent have been given a lot of reason to be suspicious of authority figures showing up. But what was clear to him is that he was not going to be able to get a petition for rehearing en banc to the Fifth Circuit. Literally, he was not going to be able to physically transmit it to them in time. And so I told him I would do it, flew back, had a few days to write it, and it ended up not working. The Fifth Circuit didn't decide to consider it, but the publicity that some of the cases had gotten, and for me, frankly, it's a bit of a mystery, because I talk to people who have terrible things happen to them in prison every day. And for reasons that I can't totally explain, some of those stories really strike a chord with people and a lot of them don't. And this one really struck a chord with people. And so people at the time, and I know your work on this, Anya, were optimistic the Supreme Court might re-examine qualified immunity in a more powerful way. Mostly people were looking at this through the context of policing. Right. And so I wanted to bring in somebody who was more familiar with Supreme Court practice, and that led to my tapping Elizabeth, my trusted advisor and friend, and her colleagues like Kelsey Corcoran, who are people who really, really know how to litigate at the court, which I don't as much, and certainly didn't back then.
And you, Elizabeth, and Kelsey, you both at the time were at ORIC, right?
Yeah, that's right. And
now you both are at ICAP.
That is correct. Kelsey.
All right.
I followed her to ICAP a couple months after she left ORIC.
Very cool. So Sam comes to you and says, okay, Elizabeth, I need help. What do you say?
Oh, yeah. I mean, I was champing at the bit. I get really exercised about sort of all of these cases. I don't really triage. I'm just outraged all the time, but this was definitely one that had sparked my outrage. And I had been very, supportive of Sam going down to Texas and flying and kind of hoping for the best. And I think I helped out with the en banc petition in some sort of small way. And so I was ready to go. I was like, yep, I want to do it. Let's make this happen. ORIC was very receptive to kind of associates bringing in sort of certain kinds of pro bono. And so I brought it to Kelsey and to our then colleague, Tiffany Wright, who's now, I think, the general counsel of Johns Hopkins University. And I had already told Tiffany about this case, and she was outraged too. So we were all really on board and wanted to get it on file. I think that's something that we think about a lot as civil rights practitioners is the sort of the concerns about trying to bring cases to the Supreme Court that could make the law worse. Right. And frankly, this just wasn't one of those cases. The law on qualified immunity is about as bad as we thought it could get, and there was, as Sam mentioned, some rumblings about maybe the Supreme Court is ready to chip away a little bit at it.
Because
Justice
you kind
Thomas,
of had
Justice
statements
had
from
been,
both sides of the ideological divide.
Had been saying, hey, maybe this has gone too far. Maybe we should take a look at this. Is this really consistent with sort of, the original meaning of Section 1983? And there was a big pipeline of these qualified immunity cases that the court was considering at the same time.
Yeah, and so what did court do in Taylor, and what do you think it means going forward? Because I think that there is a little bit of a discussion in terms of like how narrow or broad the ruling was, but I want to kind of hear it from you guys who actually litigated it, and from the perspective of like you actually getting the opinion in hand, and kind of what your reactions were.
Yeah, so by the time the opinion came down in Taylor, the court had already denied cert in some of the policing cases that were a little bit more high profile, and felt like, well, if the court's going to take a big swing at qualified immunity entirely, we made that argument that they should reconsider qualified immunity. We think it's really strong on the merits, and it also seemed like there was an appetite for it at the time. When Taylor came down, and so Taylor was a summary reversal. There were 8 justices took part in it, not all 9, and it was 7-1. And the only dissenter was Justice Thomas without a dissent, just noting his dissent. And we think that's because he does not believe that the Eighth Amendment applies to person conditions whatsoever, and not his views about qualified immunity. So we think the opinion, it did at least one really important thing, which was that this opinion, Hope versus Pelzer, from 2 decades earlier, had held that an obvious constitutional violation does not need to find directly on point precedent. And I think a lot of people had considered that case dead, that because that case came down, and then years later, the Supreme Court went on this string of summarily reversing qualified immunity opinions, that they weren't citing Hope. They weren't talking about Hope.
Right.
So you can read, dozens of law review articles that make horrible puns about Hope being dead in the 2010s.
It's just too easy. Come on,
if you're
guys.
willing to subject yourself to that.
Abandon hope.
Yeah,
Hope
abandon
is
hope. All
abandoned.
you enter here. The first thing that Taylor did was it reaffirmed the principle of hope. To Elizabeth's point, and perhaps this is undue optimism, but the world of cert stage briefing, it's not one I'm totally familiar with, except in filing briefs in opposition, because the Supreme Court is just such a hostile environment on a lot of our issues right now. And so one takeaway that I have from Taylor is that 7 of the 8 justices did sign on to the idea that the Eighth Amendment does regulate prison conditions, because I think there's some fear that even the very low bar of current Eighth Amendment law is going to go away on a purportedly originalist analysis, although there's not a lot of originalist evidence actually backing that up. So I think that's another important thing it did. And then it's not to overstate the importance of it. I think the cert petitions were trying to undo qualified immunity or take a huge bite out of it. And I don't think that's what Taylor did, but I do think those 2 steps are significant. And then I think the third step is about a related petition called McCoy versus Alamo.
Yes,
yeah,
I wanted to ask you about that too.
Yeah, so this is another case that I worked on with Danny Greenfeld at the time at the MacArthur Justice Center. And he, Mr. McCoy, the opinion was authored by the same judge, and the opinion basically has the same reasoning of, it's not about notice, it's about logic puzzle. We have a case about getting punched, we have a case about getting kicked, but we don't have a case about getting sprayed with mace.
Which, by the way, has a very powerful dissent from then Judge Costa, who basically said, this is ridiculous. You can't tell me that the instrument of excessive force is something that should be legally significant for purposes of qualified immunity.
That's absolutely right. And these 2 opinions were so hand in glove that actually in the Taylor opinion, the opinion actually refers to him once as McCoy on accident. That the same judge was drafting them at the same time. And nobody caught this at the time because it came out several months before the McCoy opinion, presumably because of the dissent. But But the author could not get these two stories straight, and it somehow squeaked through you can look on Westlaw, it's still up there with the flipped names. And so
it's like Ziegler versus Abbasi has this famous typo where they refer to the FBI as the defendant in Bivens lawsuits rather than, the Bureau of Narcotics. And now apparently an agency really matters, even though the Supreme Court itself screwed up what agency it actually was.
Yes. Wonderful. The Bureau of Narcotics did not exist when Bivens itself came out. It took long enough to litigate that by the time the Bivens opinion came out, the Bureau of Narcotics had been defunct for the last 3 years, and none of the justices thought to mention that it was important. But now it purportedly is. That is exactly right.
So McCoy, you really think McCoy involved excessive force claims, right? Which were different from Taylor versus Riojas. And you still got a GVR in McCoy.
That's right. So we got a grant vacate and remand in McCoy citing to Taylor, which connoted that Taylor wasn't just, these are really shocking conditions.
Right.
And we're only dealing with, filthy, disgusting sewage conditions. It was a broader principle of we are returning some idea of notice, at least to these Eighth Amendment claims.
Right. And there's also, like, Hope versus Pelter, I think, is remembered as an obviousness case, but it's really not just an obviousness case. It's also a case about, reasonable application of the clearly established law standard, which shouldn't just be extreme exact specificity. Right. So that's kind of another thing that I kind of take away when I think about Taylor and McCoy and the cite to Hope versus Pelter.
I think that's exactly right. And I think one reason that Hope was treated as forgotten and we were subjected to all those terrible puns is that before it makes this point about obviousness, it relies on authority the way that you're supposed to, but in a way that is just much more casual than the very methodical approach the Supreme Court has imposed since 2011. And so I think people saw the analysis of the precedent and saying, well, that's obviously not how we're doing things anymore. So then when it made this transition to, even if we didn't have this precedent, it would be obvious. I think it was easier to cast Hope and its obviousness principle. And again, I like to think of Hope and Taylor as less about there's some sort of exception to finding precedent than there's a focus on the notice to defendants, because unlike the Fourth Amendment, which has excessive force claims, which is where so much of the attention is, where the legal standard, it's use reasonable force, and that's pretty vague. But in the Eighth Amendment, we're dealing with standards like malicious and sadistic for the very purpose of causing harm. So maybe without exactly on point precedent, you might not know it when you see it when it comes to use force reasonably. But normally you do know it when you see it, when you see malicious and sadistic force for the very purpose of causing harm. And you don't need opinions to go case by case by case. So, but that's all to say, I think you're exactly right that Hope is sometimes remembered just as an obviousness case, and that's not exactly right.
I think maybe another way of thinking about this, and it's not precisely the way the court articulated it in either Hope or Taylor, but is almost a sliding scale of how precisely on point the precedent needs to be, depending on the egregiousness of the conduct. Mm-hmm. So in the Hope context, it's like, well, you have this obviously egregious conduct, and then you have some cases that establish these broad principles, and we're not going to make you find a case in which a person was hitched to a post for exactly 7 hours, in these precise Hope-like conditions, or held in these horrifically unsanitary conditions. Like the egregiousness of the conduct establishes notice, and then you're looking for cases that establish the general contours of the legal principle that the officers were meant to be applying.
Yeah, I've seen the sliding scale analysis in some circuit courts and find very helpful. I've also seen some circuit courts trying to do the split-second decision-making versus everything else, which is interesting too. But like the courts are obviously kind of grappling with this idea of like, it can't just be like obvious and non-obvious, and anything that obvious gets a little bit more of a deference, and all the non-obvious stuff, we're just going to look at facts. It seems like circuit courts are taking, are genuinely trying to grapple with that, where, at least some of the judges, and try to introduce some sort of a reason that is more complex and deals with, like you said, Elizabeth, kind of the circumstances that a police officer or any other government official confronted and the kind of actions that they took.
It's also really hard to say what is obvious.
It's in the eye of the beholder, isn't it?
Exactly. Just by its very nature, whether something is obviously unconstitutional is quite difficult to articulate. And actually, if you look at the Taylor cert petition, when we were trying to say that the conduct was obviously unconstitutional, we analogized to the conditions that were held obviously unconstitutional in Hope, which isn't to say, like, this is obviously unconstitutional. It's like, this is our best precedent on what it means for something to be, obviously unconstitutional. But, like, in a vacuum, like, it's obvious to me that all of this is unconstitutional. But a lot of judges don't see obviousness the way that I do. And I think Sam also made the point earlier, like, just to talk about the sort of effect of Taylor, like, he sees these kinds of things every single day. These kinds of egregious conditions, which in the Taylor case really captured some public attention and were deemed particularly horrific by the Supreme Court, this is actually not that far outside of things that people in prisons are subjected to every day. And so I think having Taylor on the books is also important for people who have been subjected to similarly egregious conduct, which is not as rare as maybe casual observers would like to believe. It's a
big bucket of constitutional violations. Yes, and that kind of brings me to the point that I wanted you guys also to discuss, and it's what happens now in like federal prisons, right? And you two were on the briefs and argued the Silva versus United States case, right? And speaking of malicious and sadistic conduct, that case had that, right? Like the corrections officer walks into the cell, right? Even though he's not allowed to, because then you're outside of security cameras, and then slams the prisoner on the floor, jumps on his back, and applies pressure with his knee, right? So like just really, really bad conduct. But here, unlike Taylor, where you only deal with qualified immunity, here you actually have a federal prison. And so now you have to deal with the problem of the right to sue in the first place when it comes to federal officials. And today it really comes into a kind of stark resolution with ICE raids, right? And how federal officials behave there. So can you talk a little bit about kind of this additional problem that you have when you're actually talking about federal officials, and now even in the Eighth Amendment context, even when a constitutional violation is obvious, that you are having a problem suing those officials who conduct themselves in this manner?
That's right. The origin of Silva and how the dividing was between the briefing and the arguing, Elizabeth was the principal author of the briefs, which is what you would want if you were the client. And then
thanks, Sam.
Our parental leaves, my wife and Elizabeth had kids a few months apart, and so we thought, okay, if the argument's this date, Elizabeth will argue it. If it's past this date, I'll argue it, and if it's right in the middle, I don't know what we're going to do. But fortunately, it was after, so I was able to go and be criticized and humiliated by the 10th Circuit instead of Elizabeth as a new parent while she was at home with her baby. So she kind of won on that one.
But we lost.
Yeah.
Won the battle.
Lost.
The opinion is just crazy, right? And it's just so dismissive, like in light of, post Egbert versus Boulay, where the Supreme Court says, we really seriously mean it when we say we don't believe in implied causes of action under the Constitution. And so it's egregious facts, but you're not allowed to proceed.
Yeah.
We have a number of these Bivens appeals now, both in the only two contexts that are left, which is the Fourth Amendment search and seizure context and the Eighth Amendment medical care deliberate indifference context. And the circuits have basically split on, especially post Egbert, which is interesting because Egbert didn't really make new law, in that even 5 years before in Ziegler versus Abbasi, it was clear that once you got to step two, step one is this the same context as one of our three previous opinions, which
which means
is
that it's identically on the facts. Yeah.
Is it near identical? And then if not, do we have a reason to extend the remedy to a new situation? And what was clear from...
Well, it's actually a reason not to extend the remedy to a new situation. Is there any reason in the entire world that we wouldn't want to have a remedy in this context? So it's like huge thumb on the scale at step two. Like once you get to step two, you're just done.
Yeah, so it was pretty clear from Abbasi that once you got to step two, you were cooked. And yet 5 years later, Egbert, which is only a step two case, the Ninth Circuit had conceded that it is a new context, but said that there was no reason to counsel hesitation. Because the language is just so dismissive of Bivens claims, and because there was a slight change in the makeup of the court, it shouldn't have made a difference, but instead it went from there being virtually no Bivens claims to much fewer still. And so what we now have is we have a circuit split in the prison context where two circuits at least, that you could argue three, have basically said, we are not going to allow any Bivens claims, period. And which is a pretty shocking thing, in that Abbasi itself said that Bivens claims are still important in the original context.
Right.
And
in
lower
kind
courts
of the heartland. Yeah.
Right. And there's a lot of talk about just how small is the heartland of Bivens. The courts talk about the heartland of Bivens. This is like a thimble.
Yeah.
And so we have a few courts where, the conduct has to be basically identical, but in the world of, a couple 100,000 people in federal prisons and with federal agents, and it's true that with ICE agents, those claims are totally off the table now.
Right.
That really we're talking about sort of line level domestic law enforcement doing excessive force or illegal searches in near identical circumstances. And that's the good side of the split.
Yes. And what do you think, though, in situations involving United States citizens, right? When ICE within the, inside the country is detaining and using excessive force on U.S. citizens. Do you think there is still a possibility that some circuit court is actually going to allow a Bivens claim to proceed? Elizabeth, what do you think?
I mean, ultimately, probably not. I wish I had more optimism. I think in the Bivens context, we're just pretty screwed. And I think there's some question of, is it better to have Bivens technically on the books, but essentially dead letter altogether in some circuits and completely narrowed to its facts, even in the good circuits? And I think this is something that the public doesn't totally understand. In 2020, qualified immunity really caught on and got a lot of public attention, in the aftermath of the murder of George Floyd, Breonna Taylor. People came to understand qualified immunity as sort of the thing that was the impediment to federal civil rights lawsuits. And obviously, in this space, there are so many impediments to being able to actually vindicate your rights. And qualified immunity is really important. It's meaningful, and I think the work that you do, Anya and Patrick, it's hugely important. But I think, Joanna Schwartz, for instance, in her book Shielded, has shown qualified immunity kicks a certain number of these meritorious civil rights cases, but there are so many other doctrines that basically make it impossible to even get out of the starting gate. And obviously Bivens is a huge one where I think the public would be shocked to know that you literally cannot even sue most federal officials for most constitutional violations.
When qualified immunity is not going to be a problem, right? When you're talking about a person like one of our clients, George Riojas, being detained for 3 days, no charges, no phone call, no lawyer, no opportunity to shower, no explanation, right? And then released just like that, again, with no explanation, nothing. The guy disappeared for 3 days. Qualified immunity is not going to be a problem in that case. But we're talking about ICE officials, right? And so we're running into the issue of not being able to sue federal officials in the first place. I agree. It's crazy to me that the public doesn't connect with this more, especially because we will see that now too with state officials on task forces helping federal officials in these immigration cases, and also other kinds of task forces, right? And again, circuit courts say that if you are working with a federal official, you're going to be treated as a federal official. So again, qualified immunity there is going to be the least of your problems.
That's exactly right.
Yeah. Well, okay. Now that we got that out of the way.
That's depressing. Anyway.
Let's talk about something more positive, because you guys both had victories. And the two cases I want you to talk about are cases that, and Elizabeth, I know you're a perfectionist and there's certain things that you wish happened in Frazier that, didn't happen in Frazier. But
I'm still stewing. It's months later. I'll never be over it.
So maybe let's start with you then, and let's talk about Frazier and tell us about that decision and why you're stewing, and also why there's actually some hope.
Sure. So sort of the backstory, Frazier versus Prince George's County is a class action lawsuit that we at ICAP, along with Civil Rights Corps and Wilmer Hale, brought to challenge the extremely unusual pretrial detention practices in Prince George's County, Maryland. And I'm just going to do a little bit of background on sort of how general pretrial detention kind of works at a very high level, just to illustrate why Prince George's County is so weird. In the ordinary course, a person who's arrested for a crime and is detained in jail, has to appear before a judge within about 48 hours. And the judge is meant to decide whether the person is going to be released into the community or has to be detained in jail pending trial. And because we have the system where someone is innocent until proven guilty, at least nominally, there's a strong thumb on the scale of presumption in favor of liberty. So the general expectation is that a person should be released pending trial unless a judge finds by clear and convincing evidence that there's no condition or combination of conditions that would ensure public safety and make sure that the person returns to court for their trial. In Prince George's County, so that's those are the two decisions that a judge is basically supposed to make. Either you're released into the community, potentially subject to some conditions like, ankle monitoring or checking in with an officer or something like that. Or there's no combination of those kinds of conditions and you have to be detained pending trial. In Prince George's County, there's a third option, which is called a pretrial referral. And basically judges get to kick the can down the road and defer the decision of whether someone is going to be released pending trial to an officer of the jail. So a member of the jail which gets money for every person it detains, basically is given full leeway to decide whether, when, and under what conditions a person is released pending trial. And this is a total black box. This is not further hearings. You are not given notice that your case is being considered. These are just jail officials kind of picking your folder out of the pile and deciding based on their own criteria whether to let you out at some point. And some of the factors that are considered, I think, illustrate just how sort of arbitrary this is. One of the factors is whether someone has a sort of an address, meaning that if a homeless person is arrested in Prince George's County and given one of these pretrial referrals, they basically can't be released pending trial. So if you're homeless in Prince George's County and you get arrested for certain offenses, you're out of luck. Another one that I find sort of mind-boggling is that if the alleged victim does not consent to the person being released, the person will continue to be detained, which is especially problematic in Prince George's County because complainants can initiate like charging documents. So you could have the same person file, like sort of the same alleged victim file a complaint against a person, getting them locked up in the first place, and then refuse to consent to them being released.
So you have conflict of interest, like
all over
compounding
the
upon
place.
each other.
Yes. Yeah. It's, and again, this is happening over weeks and months, and we're seeing sort of really horrific things happening to people. They're losing their jobs, they're losing their houses, they're losing their cars. A lot of the case, like sort of the workup of this case happened during COVID. And so we had a bunch of people getting COVID because they were detained pending trial under this unconstitutional pretrial referral system. And so we filed this lawsuit in July 2022. And so we sued both the county and the judges who are sort of giving these referrals. And so basically all the defendants put up like a ton of sort of jurisdictional threshold type objections to this case. So they tried to dismiss on sort of every ground, every immunity, every abstention doctrine, et cetera. And so we have been stuck litigating these like very initial threshold issues for multiple years. And so initially the district court sort of upheld our case against most of these claims. The one exception was that at a pretty early stage, the district court threw out our damages claims against the county, saying that the county was entitled to quasi-judicial immunity, which I'll come back to. And then sort of as the case proceeded, the judge started sort of like chipping away more, the district court rather, started chipping away more and more at our case until eventually throwing out basically the entire case on quasi-judicial immunity grounds for the county and then judicial immunity grounds for the judges.
If in doubt, invoke immunity, right? I mean, that's one of the problems I have is that it's a path of least resistance for a district court to just say, you know what, I just invoke immunity and then nobody's going to say that, I was egregiously wrong.
It did feel like as we were getting into grappling with these complicated constitutional questions, it is the path of least resistance to just get rid of the case on these immunity grounds. And the judge actually invited a lot of extra briefing on these immunity questions. And so that's sort of what it was ultimately dismissed on. It was a very complicated procedural case. I'm not going to get into all of the weeds on that, but it went through sort of a lot of hoops to even get to that point. And so that was what went up to the Fourth Circuit, was essentially the district court had granted quasi-judicial immunity to the county and judicial immunity to the judges. And then we also had sort of like relevant here, we had an argument that the district court had improperly dismissed certain of our plaintiffs who had injunctive relief claims that were still live at the point that we filed our complaint, but who had been released sort of after filing the complaint. And so we had some claims related to something called the inherently transitory exception to mootness, which comes up a lot in the pretrial detention context. And so that's what the appeal was about.
And so that tell us kind of how the court decided to split the baby.
Right. So this is the part that I'm still stewing over, of course. So I got up to do the argument and I did a little, kind of opening. And then the first question was something along the lines of, now I'm going to ask you a question that's sort of unfair because the parties didn't brief it and the district court didn't resolve it, but... And I was like, great, delightful. That's always how you want to start an argument. Yeah. And so the question that really drove the bulk of the argument was whether we even had standing at all to sue the judges. Because did we actually have the necessary sort of adverseness with the judges in order to be able to sue them? So our argument was, we are suing the judges over an overarching policy that they have established where they're referring cases sort of en masse to the pretrial services division. We are not trying to challenge the referral in any particular case. We're not trying to challenge basically individual adjudications. But because you can't sue a judge if you don't like the way they've decided your case, right? And that makes sense, right?
Right.
If you don't like the way a judge decided your case, you bring an appeal.
I feel it. Yeah.
But that's not what we were trying to do. We were trying to challenge this overall policy, overall practice, which had been solely created by the judges, right? They came up with this system, and we were trying to say this system as a whole is unconstitutional. And then it is being applied in individual cases. That's why these particular plaintiffs have standing to bring the lawsuit at all. But none of them is saying, as to their individual case, I should have been released or not. They're just saying this referral to pretrial shouldn't have even been on the table. And the Fourth Circuit saw it differently, and so ultimately agreed with the dismissal of the judges, not on immunity grounds, but on the separate issue that we did not have standing because we were basically challenging individual adjudications. We did win on getting the county back into the case. Which was a big win.
Huge win, because it's been completely made up by the district court, as far as I'm concerned.
Yes, it was. It was an unprecedented, as far as we know, ruling to give quasi-judicial immunity to a county. So quasi-judicial immunity is basically the immunity that applies to like clerks or, marshals in courts who are just carrying out what judges say. So like arms of the judge. Or it also applies to people who, they're not judges themselves, but they're basically judges. So, commissions and things like that have all the trappings of judges. But these are personal immunities that apply to people, to individuals. And as far as we know, no court has ever granted a personal immunity like quasi-judicial immunity to a municipality, to the county. And so that was the big win that got the county back into the case, and both reinstated our damages and our injunctive claims.
And so you guys appealed en banc, right? Because of like the first part of the decision, but
we did a petition for panel rehearing. We didn't ultimately do an en banc petition. Got it. Because so we did get to do supplemental briefing after the argument on this judicial, or like the standing question. But because it wasn't really briefed by the parties, it was sort of sprung on us an argument, and even though we got to do supplemental briefing, we didn't get to sort of fully get into it. We did do a panel rehearing petition where we got to sort of more fully flesh out some of those arguments, but to no avail.
And so you guys are now going back.
Yeah, so we're now back in the district court.
Yeah.
Yes, we're in discovery, and we're only suing the county at this point. Which, in some ways streamlines litigation, to just have like one straightforward defendant instead of these like complicated questions of judicial immunity and stuff sort of lurking in the background.
And I do think it's still a huge victory. We're seeing, immunity things kind of infecting other standards, right? In the Sixth Circuit, they have this case, Arrington Bay, where they are incorporating the clearly established law standard, the qualified immunity standard, for certain Monell claims, like deliberate indifference. And that's a big issue, I think, across the board, is courts basically saying that if a constitutional right isn't clearly established, meaning the individual officer gets qualified immunity, you also don't get municipal liability. So even though municipalities don't get QI, it's sort of a backdoor way of doing the same thing. Exactly.
And we've seen that in a bunch of courts. The Fifth Circuit too has the same issue coming up.
Yeah, this is something that I think is very important to keep an eye on and try to keep it separate, municipal liability from individual liability. We're actually seeing that in FTCA context as well, right? With this discretionary function exception. The government agrees that if you violate the Constitution, then the government agrees you don't have a discretion to violate the Constitution. But they're saying it can only be so if the constitutional right is clearly established. So again, they're incorporating the qualified immunity standard into a question involving government liability, like municipal liability, or in the FTCA context, you're talking about federal government's liability. So it's interesting how qualified immunity has really long...
Yeah, and I think it's one of those things where it's really appealing to some courts to come up with these sort of straightforward legal ways of getting rid of often complicated constitutional cases. You know, in the pretrial detention context, for instance, there are lots of complicated facts and many plaintiffs and things like that. And these are easier and more streamlined. And I mean, I think legally wrong, but sort of easier. One fell swoop, you can just kick the whole lawsuit out if you can
exactly
incorporate, sort of import these issues. And so I do think there's like immunity creep, I guess.
Yeah, and you guys kind of stopped that from happening in the First Circuit, so that's good.
Yes, it was a victory, and I know that it was a victory, but it's hard to, it's hard to really internalize that when the big thing that I was trying to fight at argument, we still lost on.
One step at a time.
Yeah.
Okay,
well,
Sam.
We've got a lot of briefing in our back pocket the next time this, judicial adverseness standing issue comes up.
Yeah, and listeners, email Elizabeth if you are if you're going to be working up those issues coming up. Sam, let's talk about your victory too. Finish on a real good note here. Tell us a little bit about Montana's, and it's an interesting case too because you have a pro se litigant, right, at the district court, and you have a district court judge treating him just horribly, like in the most dismissive way. So can you kind of just even like set the scene of how you come to be involved and what you end up, doing with the case once it gets to you? Sure.
So I was talking earlier about the early days of rights behind bars and tracking these pro se conditions and confinement cases. And we do other things now too, but we still do that. And so one of the primary issues that I track pro se litigation on is around the Americans with Disabilities Act, because I think a lot of district court judges are used to these extremely high constitutional standards for pro se litigants to state a claim, and they sometimes apply that reflexively, even if there's a broad remedial statute like the ADA or like the Religious Land Use and Institutionalized Persons Act, where it's just not the case that the plaintiff needs to sort of climb heaven and earth just to be able to state a claim. And so I caught Mr. Montana's case through tracking. I reached out to him. I asked if he'd like representation on an appeal. And his facts are that he woke up one morning, he was incarcerated, and big parts of his body had just gone numb and were paralyzed. He couldn't use them. He has a history of back injuries. And so he spent about 3 days ground, urinating on himself, not getting sort of echoes of Taylor there, not getting any medical care. He was eventually given back surgery and, treated decently well before he was shipped right back to the same prison he was before, where, again, his mobility impairments prevented him from just reaching the basic programs of the prison. And I think that's something that some judges have trouble understanding about how the ADA works inside prisons, which is that normally the ADA means that public entities or private businesses, they have to accommodate people with disabilities. If they open to the public, they have to open to people with disabilities too and offer reasonable accommodations. But I'm not sure courts always grasp that prisons are totalizing institutions that govern the way that people do everything. And so you cannot get a double mattress, which is one of the accommodations that he wanted, unless the prison says it's okay. You can't go to the bathroom in the middle of the night unless the prison says it's okay. You can't go take a shower after you urinate on yourself unless the prison says it's okay. You can't get a particular diet. You can't get a cane. You can't get a wheelchair. You can't live in a place where you don't have to climb 3 flights of steps every day if the prison says that you're not going to. And so it just makes disability accommodations really important to people with any kind of significant impairment, because the prison is just governing every aspect of their lives, and it needs to make accommodations in how they operate. And the ADA is all about specifically addressing one's problems, and prisons are the opposite. They're about standardization. They're about, if we make an exception for you, we'll make an exception for everybody else. So these cultures are just like in direct clashing. So Mr. Montana has these terrible few days. Then he finally gets some medical treatment. He gets shipped back to the prison and has more few months where they're not bringing his meals to his cell, so he has to walk. They're not giving him a crutch. They're not giving him a double mattress. And so he files a pro se complaint, and the court requires him to use a form provided by the court. And the form says you can attach 3 pages of allegations. So he does the best he can.
Do you know that it's a standard practice still in the Middle District of Pennsylvania? I mean, that sounds crazy.
They've changed that particular form, but it happens a lot. These forms, they're trying to help.
Right. To a non-lawyer to kind of feel out things. Yeah.
But a lot of times it ends up working the opposite way. I mean, by tracking the pro se cases, I see 100 examples of these. So for example, for these pro se people, they'll have them check a box. Are you suing people in their individual capacity, their official capacity? And that's completely unintelligible to somebody who hasn't, poisoned their brain by going to law school. And so people go, well, I'm suing, the guy for what he does at work. So official capacity, and then they get their claims dismissed because you can't bring damages claims against the official capacity. Whereas if they had just left it ambiguous, the court would have been obligated to assume they meant individual capacity. But because the forms force their hand, again, I think these are trying to be helpful.
I think it's trying to be helpful, but there's also sort of a pervasive skepticism in the courts as to pro se lawsuits, particularly by incarcerated people, right? So they're trying to help, but they're also trying to kind of shove these pro se plaintiffs into a particular format because they don't want to receive a 20-page handwritten complaint that they don't want to, so I think it's both. Yeah. I think they're trying to help people file their lawsuits, but only in a particular format to make it easier for the court and reduce the volume of the pro se filings they're receiving.
And minimize opportunities for plaintiffs to actually explain what exactly happened because they frankly don't feel like dealing with it.
Yeah, well, you both are absolutely right. I shouldn't suggest otherwise. I think they're trying to make it easier on themselves. And in some ways, they're trying to nudge the plaintiffs into the direction of stating the correct sort of claims. We had to reschedule this in part. I had a Fourth Circuit argument last week where I had a client who filled out a pro se form, and the form said on it, do not cite any statutes or cases. Just say what happened to you. And it bolds the do not cite any statutes or cases. So he says what happens to him. The court says, okay, you've brought an Eighth Amendment claim. This doesn't meet the standard, dismissed. And I appealed to the Fourth Circuit and I said, well, maybe it doesn't meet the standard under the Eighth Amendment, but it meets the standard under the ADA. And the government argued that he had waived his ADA claim because he hadn't cited
Didn't cite
the ADA.
To the ADA claim? Brilliant.
Yeah. So,
yeah.
I mean, the stuff with the forms comes up a lot. But
yeah.
So he writes 3 pages. The defendants move to dismiss. And, he has claims going across a wide range of defendants across a long period of time. So he's light on details. It's like he's got 3 pages. He's handwriting it. And so the defendants move to dismiss. And the district court grants them. And Mr. Montana opposes pro se and says, this is already, none of what you're saying is true. Look at all this other stuff that happened to me. And the district court says, number 1, motion to dismiss granted on sort of a variety of incorrect legal bases. Number 2, you're not allowed to amend your complaint by adding a bunch of stuff in an opposition, which is technically true, but of course you understand where he's getting at. And number 3, you can't amend your complaint either because that would be futile, even though the stuff in the opposition would clearly state a claim. So we went up to the Third Circuit, and my colleague Lily Novak argued the case and did a fantastic job. Again, I've shared that I feel like I see a lot of things that are pretty outrageous, and sometimes it connects with people and sometimes it doesn't, and I don't always sort of trust my own intuition. But what happened to my client in the district court, the Third Circuit was really angry about. it expressed a lot of displeasure with the way he'd been treated by the district court and treated by the prison. And so some of his Eighth Amendment claims for conditions of confinement and for medical care and for the ADA were all turned around. And now Mr. Montanez has counsel in the district court and his case is proceeding.
Yeah, it's a really kind of reading that case, like the court doesn't get personal. Sometimes some courts like getting personal. It doesn't get personal, but it mentions the district court's opinion enough times, and various things that the district court did, like objectively just states them enough times to finally for a reader to be like, I'm not sure what the district court did here was like within bounds of normal.
Yeah, and I think, unfortunately, what the district court did is a little bit normal. Like Elizabeth said, there's a lot of concern about docket management. They just don't want to deal with these cases. They don't want to deal with the handwriting. They don't want to deal with having to do the litigation by mail. They don't want to deal with incarcerated plaintiffs trying to do discovery, which is almost impossible. So they try to find a lot of people, even though these cases are so important, they try to find ways to shortcut these cases.
Yeah, go ahead, Elizabeth.
Oh, I was just going to say, and that's part of the sort of core insight of the track and intervene model that RBB set up to begin with is, you have these extremely lopsided conditions, right? Where on the one side you have people who are incarcerated, who have, limited access to legal materials, no legal training in almost all cases, and are doing this all mostly by hand, by mail, often with, disabilities, either, physical or mental. And then on the other side, you have repeat players, these prisons, jails, immigration detention facilities, represented by counsel who do this thing every single day. And just have their form, here's the motion to dismiss that we file in all of these cases. And courts aren't bending over backwards necessarily, even though, technically they're supposed to, because when you have a pro se litigant, you're supposed to, construe everything much more favorably. But courts aren't necessarily bending over backwards to do all the legal research that maybe the pro se litigants weren't able to do. And so it's just stacking, disadvantage on disadvantage from the pro se litigant's perspective. And so that's a lot of what RBB's initial cases even were just like, hey, this is an obvious legal error that the court just didn't catch because it was basically relying on sort of very lopsided briefing or something like that. So this does come up a lot. That's sort of the point.
And one reason that this particular opinion in Montana was gratifying for us is that the opinion cites 4 previous rights behind bars opinions. And so there are, especially in certain circuits, certain areas, I think the ADA more than anything, but we really saw the district court getting it wrong again and again. And again, there are systematic reasons for that. It's not just because the law is bad. It's not just because out of malice. The circumstances tilted against incarcerated pro se litigants, even to meet these standards that are already really hard to meet, just the legal standards. But one thing we've been happy to see is when the model works at its best, it's the victories build on themselves because they're doing some education of the district courts and the appeals courts about what these legal standards actually are and how to apply them.
Yeah, and this opinion really is very much, something that you hope to see in an engaged circuit court opinion, and hopefully also telling the district courts we expect more from you guys. We expect better than this. But would you say, and I'm gonna wrap it up, but in other circuits, in your assessment, what circuits would be more what you just got here, and what circuits would still behave very much like the district court did here?
That's a great question, and I think it's not necessarily intuitive. I think it can vary a lot by the panel, and it can even vary by some of the judges political ideologies. I just think some people, some of the federal appellate judges just have more of a commitment to giving people a fair shake. So I was joking about getting beaten up at the Silva argument, which I did. I've had terrible luck in the 10th Circuit. Denver's so lovely, and every time I go out there, I just get shouted at. The Fifth Circuit, we've won a lot of cases in the Fifth Circuit, despite its reputation for being pretty tough. We've also lost some, and we've lost some that I don't think there was a super strong legal argument, and it was a little bit motivated by the outcome. So I'd say that it varies, but we think even in the most hostile circuits to our clients, and even with the legal standards being pretty tough, we think there are pro se litigants stating claims in the Eighth Circuit, in the Fifth Circuit, who, if we can get in front of a panel who are going to give our clients a fair shot, then we'll take that shot and we win more than we lose.
Thank you both so much for being here, and keep on going. I hope to have you guys again soon to talk about more of your victories.
Thank you so much for having me and for having Elizabeth, Anya, and right back at you. Keep up the good work.
Thanks for having us. This is great.